I was honestly talking immediately to people, and I'm like, they're not in yet.
Yeah.
So when my computer dies, which we all know it will do at some point, I
Oh,
expect you to jump in and pick up where I left off.
well, we'll have a lively conversation about Halloween costumes to kill time until you're back.
Oh, that's right. I was supposed to put costume stuff on there. Oh well.
Mm.
All right, everybody. I can see everyone's starting to join the class. Thank you all for being here today. I'm Geoffrey Middleton, one of the attorneys here, and we got Lindsay with me today, that side, helping us out as always. We are going to just kind of kill the next 45 minutes and just hang out and wait. We usually have some late comers that kind of come in a little after time, so we try and give them the benefit. Um, since we do already have a bunch of you already logged in, Lindsay, if you have any housekeeping to do, you can go for it.
Sure. Well, first, I hope everyone had a happy Halloween. And if you would like to write in the chat what you dressed up as, I would love that because I love Halloween. So you
Nice.
can help me on this cold Tuesday morning. Um, Otherwise, as Jeffrey said, I am Lindsay. I am his realtor liaison. So if you have a contract with our office, I'm the one who will kind of guide you through the whole process and update you every week on what's outstanding, where we are. Just make sure that you are in the loop. Um, Part of my job also is to help with these classes. And so we are almost at the end of the year and we've done a class every month. We've got one more in December and then we're going to be doing it again in 2022. So if you haven't been to a lot of our classes, you can go to our website and see recordings of our past ones. But you should also pay attention to our emails that come out in our newsletter because that has first invite for, yes, Lynn, us first invite for all of our upcoming classes. And if there's a topic you want us to cover, definitely send me an email, let me know. We're very happy to work popular topics in. If you are on your phone today, I will be putting up a link at the end of the class to register for our next class in December. Just know that once you click that and you're on your phone, it will take you out of this. So make sure that you don't click anything until you are ready to leave completely. If you're on your computer, you're fine. It will pull it up in another tab and you'll still hear us. A lot of you have found the chat already. If you have any questions throughout the class, just type it in there and we will bring it up on the screen and Jeffrey will answer your questions. And I think that's it.
Do we
Just
have a
stay tuned
poll
to the
for
end of
today?
the class so that I can put the invite up for the next one. What'd you say?
Do we have a poll for today?
We do. That's also something I'm doing here. There you go.
I've got a picture of my wife and her crew at the hospital up on the screen right now just because we're killing time and why not. This is a fun thing they do at the Children's Hospital for Huntsville Hospital. Whoever works on the shift that day dresses up for the kids that are at the hospital. And it's always a fun thing that my wife, Kim, loves to do. She's the Cinderella there in the middle, for those of you who don't know Kim. So I'm always proud of her on Halloween for trying to make kids a little happier. It's always exciting.
It's a good Cinderella dress. She did a great job.
She did. She was very happy with how it all turned out.
Pretty even on the poll.
They've already answered the poll so quick tonight.
Mm-hmm. Everyone has already had their coffee today. They're all quick. Not me. Mine is still here.
And then this was me and my wife's actual costumes for Halloween,
So
since we're
good.
still doing Halloween sharing.
Those are great. Are her shoes part of it, or are those? Is she wearing separate shoes?
No, that's all part of the suit. They're like built into it. So like she's
Cool.
actually got real shoes on there.
Oh, that's awesome.
Yeah.
Also, you didn't save a photo of my costume to put up.
I didn't. Did y'all send us pictures of your costume?
No. Well, I put it in that like group chat.
Oh, okay, okay. You can share your screen, can't you?
Oh, probably.
All right, everybody, just one more minute or so, and then we'll go ahead and dive in today. Clients ever called you about property line disputes? Oh, we got a bunch of nevers. That's surprising.
Those are lucky people.
Yeah. Once you get introduced to this world, it just never stops happening. It's exciting. Brandon was none of your business. I'm really curious to see that.
Brandon, you would look good as a nun, I think.
Isn't it illegal in Alabama to dress up like a nun?
Yes, we found that out the other day. A nun and a priest, right?
Yeah, it's something to do with clergy or something like that.
So funny.
All right, everybody. Like I said, thanks for hanging out with us today. We've had a few people join in, so we're going to go ahead and dive in now and get started. For those of you who are joining us for the first time, this is always meant to be a discussion between me and the agent. It's not meant to be me talking for an hour. This is not CE credit. This is really just a roundtable discussion with agents and an attorney so that we can kind of talk about things you don't usually get to talk about at the closing table. So let's, oh, Brandon, I need to see this. This looks fun. But what we're going to dive into today, if I can figure out how to share my screen again, is property line disputes. So with today's theme, it's going to be all Shrek stuff. So I apologize for all the crazy pictures on my slides today. But we're going to go ahead and dive in now. This is all about when your clients call you and say, I have issues with a fence, or I have issues with this going on, or I have issues with, my sheds on my neighbor's land, all the things that happen and how we go about solving those problems. So the first things first, whenever we have any issues at all with property disputes or property in general, first thing we're going to do is actually establish what property we're talking about. We need to actually draw out the lines and figure out where my property ends and yours begins. A lot of people, when I start asking them where their property lines are, they say, well, I've always mowed it, so I think it's mine. Or, oh, yeah, that's my tree. That's not a thing. You can't just claim trees. Or, oh, I paid taxes on it last year because my neighbor was not getting to it, so I wanted to help out. Well, that doesn't make it yours either. Um, so the number one thing I tell people whenever we deal with property disputes is let's get a survey. Let's get a survey and let's do a title search are my first two introductory statements to pretty much everybody who has boundary disputes. As a side note to our conversation today, you can see at the bottom there that when you get a survey, you're going to get a legal description of the property. And I'm trying not to go too basic with you guys. I know a lot of you have dealt with this before, but I am going to touch on a few basics of the survey and legal descriptions in general at the bottom there. You see that we have meets and bounds and we have lot and block. Meets and bounds have been around since the United States was started. That's how the original 13 colonies were mapped out. Back then, it was going to be largely based on large tracts of lands or the large squares that they draw out for the surveyors. And then they moved into compass and chain type measurements where they literally had a chain. I forget how long the chain actually was, but I think it was something like 80 chains made up a mile. And 20 chains made up an acre. And so they have definite measurements that they used, and they had compasses that were just right for the surveyors. So you can see all those measurements on our surveys still today that they started back then. You can see the calls from the compass that talk about the minutes of the compass and the degrees that they're walking. And then you can see the distance of how long each chain would measure at the time. Back then, they'd say it was such and such chains, and then you could interpret that into feet. Nowadays, it's just going to go straight on measurement. The chains were, there it is, Barbara's helping me out. A chain was 66 feet, and I do believe that is correct. That rings familiar to me. Chains were replaced by steel tapes, steel measure tapes, so that they could get more accurate measurements from people. And then steel tapes were, they were in play from, I think, the early 1800s up until, I want to say fairly recently, because the replacement of the steel tapes has been electronic measurements that essentially mimic the steel tape measurements. So I think we've just in the last 15 to 20 years moved away from steel tape measurements. So when you get a survey, they use all these different tools to measure out and say, you're going to go this direction with this many minutes on the degree list, and then we're going to go this many feet, and then we're going to hit usually it's a steel pipe these days or some sort of steel measurement that's been implanted in the ground so they can mark the corners. But it used to be that they would just go to a tree. There's a big oak tree in the corner there. That's a good measurement spot that we'll stop on, or there's a creek, let's follow that creek. And so a lot of the old meets and bound measurements that are really old can get a little goofy. And so when we see old meets and bounds descriptions and title, we usually try to encourage people, you want an updated survey, because property disputes do come up, and we always want you to be prepared to know where your boundary lines are. Barbara, yeah, just step it off. That's about 10 paces in the westward direction. Yeah, that would be great. Lot and block, for those of you who don't know, is meets and bounds, but simplified. So lot and block is where you take a meets and bounds survey that pre-measures out a bunch of different blocks for houses, and then creates different lots for each house to go in. And then they plat it out on a big map, and they put that plat in probate court. And that plat is now a reference point. So we don't have to continually guess about who did that survey, and is it accurate, and does it go over other people's land, and does it overlap with other people. It's been platted, it's been surveyed, the city's all signed off on it. It's got all the things you could ever want as far as easements and encroachments for the city to have their rights to give you all the things you need. And so now we just reference its lot and block number and the subdivision that it correlates to in the plat. But that still falls back on a meets and bounds description. So getting that survey will always give you the same kind of description there, and that's what we're looking for when we talk about these problems. Common types of surveys when you're going to get them. There are a lot of surveys you can get, but in our world, we're just going to talk about these basic 4 surveys. Excuse me. Your boundary survey is, I think, what's going to fit most of you the best. It's going to be the cheapest and easiest to get as well. It's just going to establish your true boundaries based on your deed. And then they're going to come out and mark the corners and draw your lines for you so that you can see exactly what you need for your boundaries. The mortgage survey is going to be a detailed boundaries drawing so that they can actually show you where improvements on the land are and where the buildings are and other things like that. A topographic survey is going to focus more on the natural layout of the land. You can see those mostly in like elevation charts and maps of a lot of, for us, is going to be hiking trails and things like that. And then your Alta survey is something that's come along from our favorite group, the Alta people, and they have combined elements of all 3 of those surveys. And so the American Land Title Association is someone that we work with. It's a group that is over all of the land title people. So that's title agents like myself. They put out a lot of the forms we use in our closings on a day-to-day, and they're very involved in our process. And so they came in and said, you know what, to protect title underwriters like me and title insurance people, we're going to lay out some basic things that we think every survey should have. And so they really go in depth with it. They're going to show you access points from major roads or thoroughways. They're going to draw fences, trails, anything they can find on there. They're going to not only show you your boundary lines, but they're going to show you your neighbor's boundary lines just to start and see how they connect and how they come in. You're usually going to see flood zones and zoning requirements on there. And this is a very popular survey for commercial properties. But because of how detailed it is, it gets pretty expensive. And so you don't see it as much in residential. But I want you guys to know it's there. When people say, I'm requiring an Alta survey on a contract, they're requiring this. And then you have, just to back up a little bit, I think most of you are going to want this boundary survey when we're talking about boundary line disputes. And so this is usually the cheapest one. And so that's the one that you should know about when people are calling surveyors for quotes. Right now, you should know surveyors are backed up by a couple months usually because we're so busy right now. The real estate market is just exploding. And so the surveyors are just as busy as we are. So if you think you're going to need a survey and it's going to be in a timely manner that you want it, you should call ASAP. and you should specifically talk to them about the easiest one to get, which is the boundary survey. So jumping through, what are types of disputes that we're talking about when we say boundary line disputes? And I'm going to ask you guys to kind of give me some feedback here. So in the chat, if you're one of those people who said, yeah, I've dealt with boundary disputes before, give me some ideas of things you've seen in the chat about what are disputes you've seen. I'd love to actually have a dialogue with the agents today about disputes they've seen, how they solved it, things like that. I'm going to give the basics, but the conversations where this class is really going to get good. So I'm counting on all of you to have conversation ready. So to cover these disputes real fast while we're waiting on people to have some information for us, are driveways that cut across a neighbor's land. Usually that's when the driveway either curves a little bit or they built the driveway a little wider than they were supposed to. And so you end up getting a piece of the driveway on the neighbor's land. Corner of the shed is very popular. We see that all the time. Anything that's really added in the backyard can oftentimes be off the land because people don't get it surveyed before they build. Trees on property lines, we get calls about those all the time. There's lots of rules for how to handle trees. We'll go over those in a minute. Not having legal access to land. What I'm talking about there is I can't legally get to my land. It is landlocked is what we call it. So there's no roads that go to it. So I'd have to go on a private road to get to my land. We've actually talked about that in a previous class or a previous blog, I think. So I encourage you to look at our blogs for those landlocked access solutions. Neighbors, fences, there's always fence issues going on. We're going to talk about the fences in just a minute. I have another slide for that that we'll kind of finalize our class on because we had a specific question from a realtor about partition fences. So I have a special slide for that. Water lines across the neighbor's property, that's a new one to me that I heard recently. And so there's always stuff going on. I can see in the comments now we got stuff coming in. Let's see here. Fences on the wrong lot. Yep, that'll do it. Swimming pool pump placed on the other side of the fence. Yeah, that was probably convenient for them because they didn't have to look at their pump, but not legally where it was supposed to be. Mowing grass that's not theirs. That happens a lot, and then people just claim it as theirs. Well, I've been taking care of it forever and mowing it, so that's mine now. It's a little more complicated than that. Shrubs, yep, that's another one that we see is people have been taking care of land and making sure that all the shrubs and plants look nice. Shared driveways. So we see this a good bit when neighbors who are nice agree to share something and they build it together. And it's kind of on both properties. And then they start selling their property and it goes down the line and all of a sudden new neighbors aren't as friendly as old neighbors. And so now we have an issue and there was never a official written agreement on how to handle this new thing. And so now we have to come in after the fact and write that down. So that's a great example of if you have a shared anything on the boundary of a property, get it in writing so that it runs with the land. Because just because you have an oral agreement with your neighbor doesn't mean it's going to run with the land. And so that's always something that you can bring up to your clients is let's get it in writing so that we know future people won't have to deal with the same problem we did. Garage partly over neighbor's land. Yep, garages get added on all the time. And so the original builders who did it right, it's not their fault. It's usually people come in later and build on to it. That's when you get your issues right there. Shared fences, we're going to talk about. A new construction in a no sightline community. Yeah, so HOA rules and restrictions can really get you. That's another important thing to look at. So once we have all these issues, what's the process for how we're going to go about trying to solve them? This is a basic walkthrough of where I'm going to start all of our conversations and then the specific solutions that it's going to lead to. So the first thing I'm going to talk to you guys about is these are neighbors and we want to probably keep them happy with you because they're people that aren't going to go away. Usually your neighbors are there for the long term and it's always nice to have nice neighbors. But even if they're not, you need to at least be friendly with them. That's not a legal rule, but that's a life rule that I think everyone can agree on. Yeah, Lynn, absolutely. Get the chainsaw out and cut down whatever annoys you. That's the best way to get happy neighbors, I think. Just cut down the fence, cut down their favorite tree, and then bring them some cookies. um, but the main reason that I want you guys at least talking to neighbors is because it allows you to identify the problem from both your perspectives. Because I've seen people come to the table with, I have an issue, and then we get the neighbor involved, and all of a sudden it's not the same issue. It's a little different. There's a nuance there that we didn't know about. And so we always recommend at least a conversation, not to solve the problem, but just to identify the problem. You don't have to come, you don't have to bring the chainsaw with you to have the first conversation with your neighbor. Have a kind one. And then the next thing we're going to do is get a title search and get a survey. We want to go mark that boundary line with the surveyor, and we want to get a title search to see, like I was just talking about before, sometimes neighbors will come into agreements historically that run with the land, and you just don't know about it. And so we want to do a title search to see, has this ever been mentioned before? And is there any record in title that's going to show who actually owns this thing? Or is there any agreement around this thing, this problem? And then from there are lots of specific solutions to individual problems. Sorry, I'm trying to read all your comments while I'm talking, and it's great. Neighbors flowers, oh my goodness. So I think some of the more common solutions that we see are going to be an exchange of land. So we had clients in the past that they had a driveway that kind of meandered, and part of it went over the neighbor's land and part of it went over our client's land, and they had both used it together at different times, and so it was never a problem. But as we just discussed, people don't write these things down. New neighbors come in, new owners come in, and now we got to figure it out. So what they did is the neighbors built their own driveway, so there was no longer a shared reason to have the meandering driveway. And then they just had a surveyor come out, surveyed both lands, and they drew a new boundary line right up the middle that actually ran with the driveway. And so what happened was is since the driveway went, kind of meandered back and forth, they just took lots of land from each one and took what was a straight line and made it curved, and we just quit claimed the two pieces of property to each other. So it was a net situation. Neither one gained land, neither one lost land. We just straightened out the actual boundary line so that they could say, this is where my property is and I have control of it. So that's always a good solution, is let's survey the property, figure out where our issue is, and then we can quit claim the proper land to it, and then we can actually record the survey in probate, so it'll never be an issue again. Another one is like if your shed or your pool or pool pump or house is on a corner of your neighbor's land, you may have to actually purchase that corner of land to extend your boundary. And again, that's just one of those situations that you have to talk to your neighbor and figure out, what's going to work best for us. Is this something that they're willing to sell to you? And how can we best make it work out? And then, of course, easements are always great. Easements are, if there is a driveway that is a shared driveway, but only you own the land on one part and they own the land in the back part, then giving them an easement for your driveway is the best way to do it, because that easement is going to line up a lot of different things. It's going to line up who can use it, how they can use it, and also repairs. How are we going to fix it when it eventually degrades? And so that's important to have. Boundary line agreements are similar to those easements, except instead of giving someone access, we're going to discuss, on this boundary line issue that we have, we're going to share X, Y, and Z. We're going to take care of A, B, C, and here's how these neighbors have agreed to do it. And then we're going to file it in probate so that, again, it runs with the property. And then we're going to talk about the fence agreement in just a minute. So if none of these things work, if we can't come to any resolution whatsoever, and all of these friendly neighborhood conversations that lead into legal agreements in probate, none of them are coming together right, then what you can do is actually go to court and get what's called a quiet title action, where the court is going to say, look, there's a dispute over this land, and so we're going to let each of you present your evidence as to why you think you're the one that should walk away as the true owner of this particular issue. And then we're going to issue a final ruling on it, and that'll be it. It'll quiet the issue so that no one's ever going to yell about it ever again. So we can always go to court to quiet those issues. And that's called the quiet title action. So we typically try and avoid that at all costs because it can get costly for the neighbors. It's usually over a small thing. And so we typically try and encourage other solutions, other non-judicial solutions first. Let me jump into my fence slide real quick before we resolve all this real quick. I know this one's not as fun looking, but there's an actual Alabama law about what they call partition fences. Partition fences are where a fence is actually on the boundary line of the property. And if it is only being used by one neighbor, great. That's their fence. It's not a big deal. But as soon as your other neighbor ties into your fence and now uses it as the agreed upon boundary of the two lots, well, now we have a partition fence, and that is a shared cost expense. So the person who originally built the fence can actually have their neighbor who tied into it pay a portion of what it costs to build the fence in the first place, with obvious time and wear and tear taken from that expense. And they can also require a shared expense and upkeep for that section of the fence that they are sharing. This is a statute. It's not debatable. If you move into a house and your neighbor's got a fence and you're like, I want a fence too, and I'm going to tie into that, you are making yourself subject to this law. It's not going to be a debate about it. Now, if you debate how much it's going to be, then there are court proceedings for how they go about doing that. Essentially, it's that second paragraph or third paragraph there. What if they don't pay? It's going to talk about the court will actually find three disinterested parties to come in and analyze the fence and look at how much it costs and how much it's going to be to upkeep it in the future. And then those three, unconnected parties will then give their report back, and then that'll be the amount that has to be paid. So I know a lot of HOAs will try and make this partition fence issue something that's easier to swallow or easier to deal with. And so they'll actually have it in the HOA that if you have a partition fence, both neighbors have to sign agreements agreeing to these fees. To me, that's just good practice because it's already a rule. And so the HOA requiring it is something that's really just making all the parties have notice that this is a thing that we need to deal with. And so fences are, to me, a pretty clear-cut situation because we do have the statutes on it. But there's always unique situations. Let's see what we got in our chat. Brandon, oh, y'all are just chatting about something else. Gotcha. So that's our fence issues and how I've seen it dealt with HOAs and other properties. Do we have any questions so far? Because unless you guys have specific questions, that was the introduction summary of how we come to problems, how we generically try and solve them with non-judicial reasons, the one judicial solution that we have to ultimately solve any problem, and then of course the fences being a specific issue. I guess this is the point where we open it up to questions and dialogue from you guys. Like I said, this is a roundtable discussion. I really like engaging with you about situations you've seen or questions you have. I'm going to leave it on this slide because it's got more information about the specific solutions that we have. And then I'm going to try and catch up on the chat real quick. So give me 1 second. So I see adverse possession brought up a lot. And Barbara, that was from your comment just a minute ago. Adverse possession is a defense. It's not something that someone can walk over and go, I own your land because my fence has been there for 20 years. So gotcha. Typically, adverse possession is a much harder thing to deal with than people think it is. It's a great, fun term for people to throw around all the time, but it is not nearly used as much as people think it is. In my very limited experience with adverse possession, it's something that is like I said, a defense to someone saying you don't own that land that you think is yours. And you can say, well, I've told everyone it's my land. I have color of title on this land. I've defended my right to have this land. I've protected it and I've paid taxes on it and I've treated it like mine. And these are all defenses to someone saying, I'm taking that land. It's mine. And so typically what happens when there's a fence that's over the line, rather than having people pay lots of money to move it or redo it, something we'll do is we'll say, look, just to make everyone feel better about the situation, we can do a boundary line agreement where we say, look, we acknowledge this fence is not on the actual boundary line, but it's not in either party's, real benefit to make the fence actually move 2 feet over. That 2 feet doesn't affect my ability to enjoy my land or yours to enjoy yours. I've tied into it, so now it's a partition fence. So we're going to agree that this fence is going to stay, but that the land that it's over is my land. And so you can state in there that both parties acknowledge that that land is not the neighbor who has the fence that put it too far over. And that's enough to defeat your adverse possession claims, because then they're not holding it out as their land. Sure, it's fenced in, but there's a written agreement that says they acknowledged it wasn't their land. And that's what's going to come down to. So the adverse possession is not as scary a thing as people think it is. So I would encourage people to look at boundary line agreements when they have issues like that. Paul says, I found something quite useful with a little digging. You can find most subdivision plats on the probate website. Yes. In fact, the plats are fantastic. You can absolutely find them. Madison County just redid their website. I have not been on it since they redid it because it was just this weekend, but they have a great website for finding those plats. If you know the plat numbers, you can look them up directly. As far as the nice PDFs to hand clients, your Madison County tax collector and most tax assessors in our area actually have a great GIS system that you can go online and see the maps, and they take their tax maps from the deed legal descriptions. So it's not perfect. It's definitely not a legal survey, but it's a great, starting point of, am I even in the right line of thought here? And then you can go from there and get an actual survey and have them actually mark the boundaries. But a tax map's always a great way to start. Barbara, you do have to pay property taxes to claim adverse possession, don't you? Again, you'd only be claiming adverse possession as a defense. You wouldn't walk up to a neighbor and say, I'm taking your land by adverse possession. So generally, you'd be paying those property taxes on it because you're considering it your own anyways. And so paying property taxes on land it can be part of the adverse possession process. Again, it's going to come down to unique things. Like if you're talking about a sliver of a 2-foot piece of land that's just running between your two properties, who's paying the taxes on that? Is it already part of your tax bill? Is it part of your neighbor's tax bill? Is it really going to affect your tax bill? Now, if you're talking about there's a separate lot behind my house, no one seems to own it, we can't find the owner, taxes have never been paid by anybody, I'm going to start mowing it and I'm going to put a fence around it and I'm going to start paying taxes on it and I'm going to consider it mine. Sure, that might be a great way to start your claim for adverse possession in 20 years when someone says, hey, that's my land. And you can say, well, no, I've been taking care of it for all that time and I treated it like mine and I told everyone it was mine. Then you might have a defense there. But again, I will never advise a client to rely on adverse possession as a claim for title, just because it's a risky claim to make. There's so much time involved and there's so many steps to make sure that you've done it properly. It's better just to try and get a quick claim deed from the person who owns it, or to try and locate the owner, or if you can't, do a quiet title action. So there's lots of options to get property besides adverse possession. There's one takeaway I can get you guys to take away from this class, is that there are a lot of solutions to property disputes. Adverse possession should be on a different piece of paper. Just when you're going through your list of, here's some solutions we have, don't put adverse possession on your list. These are all active things you can do to solve disputes, and these are things that I would recommend that we go down. There are things we can file in probate. These are the ways to do it. Your adverse possession is just a talking point to make you sound cool most of the time. Now, there are situations where adverse possession has been used, and it is a great tool and it's a great thing, but I wouldn't start most of your conversations there. Barbara, I see you got a post there. I had a listing this year where property was obtained years ago via tax sale, went back into the 1940s for a legal description, which was messed up. The tax map showed it on the wrong street. Yeah, it happens. After much discussion, tax assessor admitted it was double tax, and the owner was able to get 2 years worth of taxes refunded, and she didn't owe anything. That's fantastic. Tax assessors, just like everybody in the land title world, all of our technology is getting better and better all the time. So I read an interesting article that was talking about specifically surveyors and their ability to locate errors in the survey descriptions. And in the last 15 years, we've gotten so much better at getting the minute details of the surveys accurate that most of our jobs nowadays in the title world are fixing those errors from previous surveyors who just didn't have the technology to know that what they were doing could be better. And so a lot of times you'll see us playing catch up with the tax assessor or catch up with other landowners trying to solve the problems, which I feel like is just part of our world. You just have to expect that there's going to be issues because some of this land is old and some of it hasn't been conveyed in many years. And you get a lot of oral agreements amongst parties, especially older parties who are just being good neighbors that should have probably been written in the probate. And so we have to fix those things for the next owners.
Jeffrey, you
So,
read it wrong. She didn't own anything.
oh, I did read that wrong.
Much worse.
Yeah, so that is a crazy story. That's a crazy issue. Um, so they auctioned off a property at tax sale that didn't exist. I fully believe that. I have seen other tax issues where things were sold out of a tax sale, and then the tax assessor had to admit that, hey, those taxes were actually paid, and we just had two different parcels assessed to the same land, but it was the exact same parcel both times. And so I think that's actually similar to what Barbara is actually saying, is that, yeah, they bought something at a tax sale. Tax sale purchases, just so we can get this out of the way, are a mess. Buying things at a tax sale do not give you marketable title. You have to get marketable title down the road. They will give you, I think, a tax deed after 3 years of having a tax lien on a property that you bought at a tax sale. But that usually is still going to require a quiet title action to clean up your tax sale purchase. And again, it just comes down to a lot of the issues with tax sales that come up. My office typically doesn't handle tax sales because they get very complicated, and it's not one of our typical areas that clients need us in. So if you have tax sale issues, you can always start with us, but we're probably going to refer you out to somebody who does it on a more regular basis. Just to throw that out there. Stephen, what part does the HOA play in fence sharing cost disputes? That's a tricky question because that's going to play into a couple different things. The HOA might mimic statutes that are already in existence, like the partition fence statute, in which case that would really be a disagreement between owners, not really for the HOA to be involved in. But some HOAs will actually have their restrictions mimic some of that language so that they can be involved to say, they were given notice, we talked to them, like here's some extra information about how that played out. But as far as the HOA actually having a legal say in the matter, I don't think that's going to be as important as the neighbors. The HOA may be able to help protect people's interests, like, for instance, the fence issue, where you have a neighbor who's incentivized to build a fence because it looks nice and it helps his neighbors tie into it. And then when those neighbors tie into it, um, none of those three parties may know the fence rules and who's supposed to pay for what and how that works. And so having the HOA get involved and be a part of that dispute of saying, no, this is a rule. Yes, it's part of our HOA. It's also part of the statutes. Now we all have to share these costs of these fences together. That can help protect the landowners that are in that area. But as far as the HOA being involved in that, it really depends if this is a statutory issue between owners or is this a restrictive covenants issue that an HOA is enforcing. or who's the one that brought the issue to the court system or to the lawyers, and who are we enforcing the issue against. And so sometimes the HOA could be involved and sometimes not. So Stephen, I know that's a convoluted answer to your question, but it really does just depend on what is the exact issue we're dealing with. And I can throw that uh, fence post back up here. I know it has a lot of words on it. That is the actual statutes there. I did not go through and type all that out. The statutes are actually written pretty well, which I can't always say. But these particular ones are very easy to understand with the definition of partition, what happens when people join into it. Um, I thought it was pretty clear that even if you don't mean to, if you just tie into a neighbor's fence, I mean, you're in it. You're in the game now with the partitions. Um, so I'll leave that up there if y'all read through if you want to. And of course, Lindsay can always send this out to you guys if you want it.
Yeah, just if you reply to the follow-up email that you get after this, it'll go to me. And if you want the slides, I'm happy to send them out. I have a question.
Absolutely.
The water line being like beneath someone else's property, what happens there? Because I mean, you're not gonna like move the water line, right? You just get an agreement that it's okay.
Typically, when you lay the line initially, you're going to have an agreement to have that, whether it's an easement for the utility to cross that property. That's what the city always does. Most of you don't even realize it because it's part of your plats. But the city has easements across the entire subdivision that are when they're platted, saying we have a right to run our utilities through your lands, and we have a right to do all these things. And so, when you're out in the county and you don't have a platted area like that, you do have it where neighbors may be friendly with each other for one generation and they run water lines across the neighbor's land, and the next generation comes up and says, I don't like that your water line's there. And now you have an issue because your water line technically doesn't have a right to be there because the city didn't get an approval for it, you didn't get an approval for it, the previous neighbors didn't get approval for it. It was all just done. And so that creates unique situations where you either have to run a new water line and contact the city about where that line's going to run to on your land, or if you're out in a county and maybe the city doesn't come out as far, or whoever you're tying into for water doesn't come out that far, you may have to find a different neighbor that will agree to an easement that you can then run water lines across. So that's just one of those things where no matter what you're doing, especially in the county, you want to put whatever you're doing in the probate record, even if it's just to say, yeah, this was discussed and yeah, the neighbors agreed, and here's the easement, or here's the right, or here's the dispute, something to run there. Barbara, I see your next question there. If I don't tie into my neighbor's fence and I leave a gap, is it a partition fence? No, that's just your fence. That's only benefiting you. So if you build your own fence and you don't tie into your neighbor's fence, it's no longer a shared fence. It's no longer a shared partition. You have your own and they have theirs.
And then you still have to take care of the grass that's on the other side of that, right?
Yeah, and that's an HOA could get involved there if they have rules about grass mowing or keeping your lawns manicured or things like that. So if you do create a boundary between or a gap between the two fences, that's something to consider is upkeep on that land. Who's responsible for it? Is it yours? Is it your neighbor's? Is it actually shared? Like you have 6 inches and they have 6 inches. Those are things that you guys just have to figure out as you go forward. Typically, that's not going to become a legal situation so much as a practical one with your HOA maybe fining you for not doing upkeep on it. But that can all be worked out in the planning process. The perpendicular connection rather than the parallel. I'm such a visual person, Barbara. I cannot fathom the connection you're talking about.
Perpendiculars across.
Yeah, but I can't figure out how the fences will work. Like, how does this actually lay out that you're talking about? And Lindsay, if you understand it, you're welcome to dive in there. And
I mean, I would just think it's like the corner of the fence to like the diagonal, the corner of the diagonal property fence.
There would be no shared property line there, so there could be no reason for a partition fence. Because what we're talking about is shared property lines. So if not parallel, then what are you sharing? My neighbor has a fence on one side. I built a fence along the back line.
So there's a gap still.
So if your neighbor has a fence on the property line, and if you were to build a fence, you would have it here, but instead you just don't build this fence at all, and you come up here and you just build a fence right there, and you don't connect the angles here. I think that's what we're talking about, where you just kind of have a back fence right here. I would argue in that situation that you are using their fence as a partition fence, and that you don't feel the need to finish your fence because theirs is already there. And so you are benefiting from that partition existing. Um, Now, if you were to finish your fence and come down the line parallel, now there'd be argument that you're no longer using that fence. But because you built a back fence and arguably probably another side fence, um, you are using that partition fence exactly how this statute seems to intend its use, even though you're not actually tied into the corner of it. So that's a situation where it's really good between you and your neighbor. If your neighbors are good with it, you're probably going to be fine. But if your neighbors ever asked for you to help pay for it, then that would be something that arguably the courts would have to come in and hear sides and hear your differing opinions on how that works out. I don't have any clear great guidance for that, but that would be my assumption, is that this statute appears to be talking exactly about that kind of thing happening. And that if you're truly benefiting from that fence existing, then it's considered a partition fence.
Some real sneaky thinking there.
All right, guys, these are great questions. Yeah, sneaky clients are a real thing. We've all dealt with those before. These are great questions, great feedback from you guys. Keep them coming if you got more. Um, the dead tree, yes, we did talk about the trees. So the tree situation is, and I have a blog about this on the website as well, about trees
I'll
specifically.
find the link to it right now.
But trees come down to the trunk of the tree. Is the trunk of the tree on your land or is it on your neighbor's land? And if the answer is neither, it's actually on the boundary line, then you have equal ownership of that tree. And we're talking specifically about the trunk now. Even if you could say, if we drew a line straight up from the boundary line, that trunk would be 90% on my land and 10% on my neighbor's land. Great, you have an equal share of the tree. It doesn't come down to percentages of the tree trunk. And so you have to agree on what you're going to do with that tree if it's truly on the boundary line. Now, branches and roots, whole different world. Branches and roots, if they're on your property, you can do whatever you want with them. There's no mutual consent required. You're allowed to trim those branches, trim those roots, take care of the things you need to. But the tree itself cannot be removed if it's on that property line without dual consent of the neighbors. Now, this leads us into the real question at hand, which is, what if that tree that's on the property line is dying or is dead? My neighbor still loves it because they've had it for years and they don't want to cut it down. Plus, their house is off a little bit from the side and they're not at risk. Whereas me, I'm right next to said dead tree or dying tree, and I want it taken out because it's a risk to my house and my property. Well, now we're at odds. And so the best thing you can do is set up um, the right sort of evidence or the right sort of facts to show negligence on your neighbor's part. So in the past, I've talked to people about, go to an arborist or go to a master gardener and have them come out and look at the tree and tell you for a fact, I'm an expert. This is a dead tree. This is a dying tree. And then submit that evidence to your owner and say, I'm giving you notice in writing. This tree is a risk. It's dead. It could fall. Its roots aren't doing what it's supposed to do. It's getting weaker. It could cause great damage. And if your neighbor still says no, well, now you've set up a claim so that when that tree falls and damages your property, you can come back to your neighbor and say, sorry, guys, you were negligent. You didn't take the proper action when the proper evidence was submitted to you about the tree. But you still can't remove the tree yourself without your neighbor's consent. You can have lawyers get involved with demand letters, and you can, like I said, send lots of information to that client and scare them into it, or try and use some sort of tactic to get them to agree to it. But at the end of the day, the tree rules have been pretty ironed out in the court systems. And again, those courts are actually in that blog where you can go read. I reference the cases and tell you guys how it all lays out in the long run. So if you have questions about trees, we'll be happy to help you out. But typically for me, if it's going to come down to a negligence issue with my neighbor, that's not a law that we practice here. We don't do any kind of torts or liabilities or court actions like that. So we may be able to guide you through the initial steps of how to deal with that neighbor. But if it's truly going to come down to court action, we're going to have a guy that we refer you out to.
So you just have to then wait for the tree to fall on your house.
In that situation, you are in a tough spot. I would I would highly encourage that discussion with your neighbor about the danger to your house, about having the arborist come out and say, yeah, this tree is a true danger. And then if the neighbor still won't do it, you might be able to get court action to tear it down if you truly think it'll cause danger to you. But that would be beyond me because I don't do litigation on trees. Filio, in cases where someone gets permission to connect to a current neighbor's fence and then the home sells, is this enough to keep a future neighbor from claiming you are sharing a fence and require payment? Um, if I understand your question correctly, you're saying I have my house, my neighbor has theirs, neighbor has a fence, and I walk over to my neighbor. We're friendly with each other. I bring cookies, and I say, "Can I tie into your fence in our backyard?" And they say, "Sure, not a problem at all. It's already there anyways. No big deal. You tie into it, all's good." He never asked you to pay for it because they're nice people. New neighbor buys the house, and they move in and say, "Hey, I see we're sharing a fence. I would like for you to pay for the upkeep on that fence." In my opinion, that would be a valid request because we don't have anything in writing from the previous neighbor saying that he agreed to take on the sole expense of that fence and that you're tying into it didn't obligate you. Um, you can always waive your rights and try and help people out, but that doesn't prevent other people from enforcing their rights. And so if you don't have anything in writing saying this is our agreement, this is our boundary line agreement, this is our fence agreement, whatever it might be, that goes in record, then you're kind of in a tough spot. Um, so, enjoy your time with your good neighbor and hopefully bring some brownies to your new neighbor and see if you can do an exchange of goods rather than services. So, Vallejo, I know that's not a great answer, but that's how I understand your question to be, and that's how I understand the current statutes that I've read. So, as always, guys, nothing I'm saying is meant to be taken as legal advice on specific situations. These are all generic concepts that I'm applying generic legal principles to. If you have legitimate concerns about current situations you're in, I encourage you to contact an attorney directly to talk to them about your specific situation with specific nuance so that we can figure out the right legal approach to it. I'm always happy to do that with you guys as well. But this class is really just about getting topics out into your world, hear new things, be able to talk to your clients about some things, and always be able to say, hey, I had a class on this client of mine, but we should go talk to the attorney. Come on with me. Um, so always feel free to do that. Barbara, you're absolutely welcome. I'm so glad that we get to do these classes with you guys. I really enjoy them, and I absolutely love it when y'all give me feedback and actually talk to me. So this is great. Thank you so much.
I'm going to throw up the link to the next class just before people start ducking out.
Sure, absolutely. So next class, for those of you who can't read that little notice in the corner, is death, property, and probate. We're talking about inheritance or successions, depending on what state you're from. And we're going to talk about how that plays into property rights, how that may affect your closing process and what's going on with you there. So we should definitely be able to answer a lot of common questions we have about the probate process. All right. Well, do we have any other questions from you guys? As always, you are not required to stick around. I love that you guys do, and you can ask as many questions as you want of me up until the next 6 minutes when 11 o'clock hits, because then we're out. But I really do appreciate your feedback on these classes. If you have topics you want to hear about, please feel free to ask me. Stephen called in ahead of time this week and asked specifically about the partition fences, which is why this slide even exists today. So we do try and answer your questions and reach out to your specific issues you have. You have to let us know so that we can kind of plan ahead on which class that would be a good answer for. Me and Lindsay are currently starting to talk about next year's classes. So if you have specific classes you've enjoyed that you'd like to have a refresher on, or a new topic that we've never discussed before, let us know. We'll be happy to try and tailor next year's classes to topics that you guys actually want.
I have a very random question. And I have no idea if this really falls into this topic, but I'm going to throw it out there.
Great.
I found out recently that the neighbor behind me had a bunch of cameras set up around his house and was filming all the houses around him.
Nice.
Is that legal? Like he could just film my house?
I mean, if
this guy was like a little off. He used to also come and cut the grass with a machete.
Nice.
Yeah.
Good for him. I would start this answer by saying, ultimately, I don't know the answer. But if I had to guess, I would say as long as his cameras are focused on some piece of his property, he could have a justifiable means for those cameras. And if they also happen to overlap with neighbors, so be it. Now, if he's pointing, a camera directly on someone's living room and just filming, that one thing that has nothing to do with his property, you might have some invasion claim there. But again, you'd have to be able to prove it. You'd have to be able to show, some sort of damage to your privacy or some issue, and it would just be a nightmare. So
they were on his fence, so it was not aimed toward his house.
They're on his fence, facing out.
Yeah.
That is a little goofy.
Yeah. And he has since moved, so he's not there anymore. Oh. And the new guy is the one who told us about it, and he apparently ripped them all out.
Yeah, it's creepy.
The police. I know, right? I don't know who the guy was, though. I don't even know where he is now.
Yeah, I'm glad he moved. That would have been an issue where I definitely would have advised speaking to him about that and about your privacy, giving written notice that it's an invasion and that you don't want his cameras focused on your property specifically. And then kind of set the groundwork. I'm all about setting the groundwork for attorneys to have something to use. Because most people, when they come to the attorney, all they have is, I said, he said, she said, and here's where we're at, and I don't like it. Like, well, none of that's useful because you didn't do any of it in writing. I can't prove any of it. Where are the dates for those things? How long has this been going on? So the number one advice I can give anyone who's having disputes with neighbors is do your disputing in writing. Shoot emails. Like if you are at your fence and you're yelling at your neighbor and they're yelling back, shoot a text afterwards and say, great conversation today. I really enjoy this dispute we're having. Something to memorialize the conversation. I'm a big fan of following up with emails after you have conversations with people that aren't recorded and just saying, hey, I had a great conversation today about X, Y, and Z. I'm going to do X, Y, and Z in return. Thank you so much. And we'll see you next time. So that kind of stuff can be great for setting up timelines and setting up, I told them this very specifically, and I referenced the fact that I told them this later that day in an email. And now you're not just saying he said, she said, you're validating a claim with a memorandum that you wrote, which is always super beneficial. I'm seeing everyone say thank you, guys. Thank you. We appreciate you all, and we look forward to helping you guys out in any way we can. Always feel free to reach out to us. Any last minute cleaning up to do, Lindsay, that you need?
I don't think so. Don't forget to click to register for the next class.
That's right. Everybody, thank you all so much. You have a great day. Hope you had a great Halloween. And we look forward to seeing you guys again next month, and hopefully some of you sooner than that with closings. Bye, everybody.